Okay, moving on to paragraph 13, entitled Attorney Review. This is probably the most important provision of a contract in that it gives the buyer and the seller an opportunity to send the contract after its acceptance to their respective attorneys and have their attorneys look over the contract. And then there's 4 action items here pursuant to paragraph 13. The respective attorneys can approve of the contract in 13A. 13B, they can disapprove of this contract. That disapproval is not to be based on purchase price. 13C, the respective attorneys can propose modifications to the contract, not purchase price. Those modifications shall be conclusively deemed a counteroffer. I think 13C really codifies what Illinois case law has said in that when a party proposes modifications to the contract, they're a counteroffer. The takeaway of that is that with a counteroffer, the parties really reserve a right to terminate the contract if an agreement is not had. There was no meeting of the minds. There is no valid offer and acceptance. So when making proposals pursuant to paragraph 3, I guess it could be said that the parties run the risk of losing the contract. And then in 13D, the parties' respective attorneys can offer proposals to the contract. So proposals are just that, proposals. They're not a counteroffer, which means that if an agreement is not had on those proposals, it really doesn't matter. It has no bearing on the contract, in that the contract still remains in full force and effect. Again, if there's no agreement pursuant to 13D, the contract still moves forward. So the vast majority of attorney review is handled pursuant to 13C. So what really happens here is that within 5 business days after acceptance, the parties' respective attorneys prepare a letter to each side proposing modifications or clarifications to the contract. Each party needs to submit that letter within 5 business days after the date of acceptance. Then the parties can go back and forth a little bit until an agreement is reached. 13C says that after the expiration of 10 business days after the date of acceptance, if the parties have not reached an agreement, then any party reserves the right to terminate the contract. I think that may question, well, what happens between day 5 of attorney review and day 10 of attorney review? This provision was really drafted so that in those 5 business days, it's supposed to be a good faith negotiation period where the parties really shouldn't terminate the contract, but really try to work with each other in ironing out the terms of the contract and reach an agreement on those proposed modifications. Now, of course, if the parties agree to terminate the contract in that gap between 5 and 10 business days, they can do that. But again, the spirit of this provision is really so that the parties can really try to negotiate in good faith to reach an agreement. If no notice is served within 5 business days, just keep in mind that it's deemed waived and the contract will move forward as drafted. So that kind of summarizes paragraph 13, attorney review.